Good evening, everybody. Welcome again to a new event organized by the Iberian chapter of the Chartered Institute of Arbitrators within the European branch. My name is Antonio Musategui Batalla, and I'm here in my position of chair of the Iberian chapter of the CIArb. The tema about which we are going to talk has the title Witness and Expert Conferences, Rules from CIArb, the Singapore Guidelines. The CIArb approved this year 2019, in the year 2019, with a specific purpose. Not only the path to reveal the true facts, but also a critical approach to pursuing fair and robust award decisions. In this webinar, we are going to have a roundtable whose aim is to examine the recent application of the Practice Direction 57AC, and in particular, the Greencastle versus Payne case of GR 2021 and its impact on witness statements, either about its practical drafting and the rights and duties of the parties in such circumstances. Firstly, the panel will address the English litigation landscape after Greencastle versus Payne. Then the discussion will move on to the impact of this sentence on arbitration, despite being a domestic one, English-seated, in relation with worldwide influences, and how to conciliate such decision with the CIArb, connected with the CIArb Singapore Guidelines for witness conferencing in international arbitration and other relevant soft rules, as for instance, the case of IBA Rules on the taking of evidence in international arbitration, or the Inquisitorial rules of taking evidence in international arbitration, or also called the Prague Rules. Finally, the panelists will discuss current challenges and hypothetical future trends related to witness, lay and expert, giving evidence in international arbitration. All that will take around 50 minutes an hour. Now some tips I will going to explain about public participation, I mean the attendees. The engagement tools available to the participants are these: the chat, use it for general discussion and any technical problems; the Q&Answers button, if you have any questions, please leave them in the Q&A box at the bottom of your screen. And if I see a question posted by somebody else with the support of the panelists, I can bring him to them and discuss in public. In other case, we'll stay to the last step of this webinar and openly discuss about them. Let me remind to all panelists and speakers that this event is being recorded since short minutes ago, according to provisions. And to convey with such theme, I'm going to conduct a conversation hand in hand with Nazaret Romero, a CIArb member as well. Now, it's a duty to introduce the speakers. First of all, Nazaret Romero. To the purpose of this event, his partner, head arbitration and Spanish office at Frugoli Romero Arbitration Litigation Consult. She is a member of the committees in the European branch of CIArb and a founding member of our Iberian chapter. She deals in commercial and investment arbitration and mediation concerning energy, construction, franchising, and IP rights. She is an external expert in the General Direction Justice of the European Commission and a member of the Royal Academy of Jurisprudence and Legislation of Spain. Main speaker, Mohamed Rafa, is Chartered Arbitrator, Senior Lecturer of Law and Founding Partners at Rafa, Obeid and Partners Law Firm. He is qualified at the Egyptian Court of Cassation and Fellow of the Chartered Institute of Arbitrators in London, which his areas of practice are arbitrator and financial dispute resolution consultant, dispute resolution advisors, expertise in financial and bank disputes, travel and tour operators, and arbitrators. He is member of several international commercial arbitrations, and is in charge of a team which specializes in litigation and structuring contracts for commodity and energy trades, construction contracts for Middle East and Far East contracting parties, as well, and providing consultancy for financial disputes in securities and investment derivatives. Mohammed is also lectures trade and finance at semi-governmental institutions and authorities in Egypt and Libya. And Mohammed Rafa was for 15 years till 1919 Vice President and Merrill Lynch. Mohammed was also a lecturer at Donald T. Reagan Institute in Princeton University. And Bernardo Cartoni, last but not least, is fellow in CIArb and has a triple qualified lawyer admitted to the bar of Italy and Poland and enrolled as a solicitor in England and Wales. Bernardo is listed in the SHIAC panel of arbitrator and in the as well as Shanghai, the latter one, in Hong Kong International Arbitration Court list of arbitrations. He is also a member of several arbitral institutions span all over the world. Namely, it's redundant. Now I will have a short rest, giving the rudder to Nazaret and asking to her about giving to us some light on Singapore guidelines clues on the matter about we are going to listen and learn, either from Rafa or from Mr. Rafa and from Mr. Cantoni. So then, Nazaret, the rudder is yours.
Thank you so much, dearest Chair, Iberian Chapter, European Branch, CIArb.
Bernardo, maybe you would go in until another comes back.
Nazaret.
Came into force in 2019, and these guidelines was created by the Singapore branch. For the reason these guidelines have the name as Guidelines Singapore Witness Conference International Arbitration. I would like to remark the persons, because at the end these are guidelines but are persons who are working, providing her knowledge with us: Michael Lee, Timothy Cook, Emily Chu, Chu Sin Yu, James Charles Morley, Jonathan Ellis, Richard Halley, Lau Wine Min, Loretta Malintopi, Gita Satrajani, Nisetti, Belinda Tan, David Isidore Tan. We must welcome the effort for doing these guidelines. And these guidelines are structured as offered a practical document for use by parties, arbitrator, and expert in preparation for and presentation of evidence by witnesses in conference. You must know that the wording witness conference also it is known by hot tabbing or concurrent evidence. These guidelines provide a non-exhaustive checklist of factors to consider in determining a procedure that will further the efficient and effective taking of evidence and procedural orders that may be used as a basis for crafting appropriate direction for witness conferencing. These guidelines are preparing in several parts that are an explanatory notes, and also just a moment, the guidelines are divided in the checklist, standard directions, and specific direction. Checklist, as you can understand, is a different typical question of matters for tribunals and parties to consider in determining whether to conduct a witness conference, and if so, what form that conference may take. And also the specific directions are instructed in order to this standard direction may be adopted as part of our early procedural order. And also the specific direction 3 procedural framework for witness conference led by the tribunal, the witness, and the counsel. So I would like remark that we are going to see in this seminar how concern did guidelines and which can inform Greencastle and Payne. And I would like give the floor to Mohamed Rafa, but I would like ask Mohamed Rafa what said in 1782, 4 centuries ago, Lord Mansfield on Folkes versus Chad 99 ER 589. This Lord Mansfield said that in matter of science, the reasonings of men of science can only be answered by men of science. So in this moment, we are talking and give the floor to Mr. Rafa and Mr. Cartoni, and we are talking about what said Mr. Justice Fan Code. So for this reason, I would like ask Mohamed, please take the floor and short introduction about the fact of Greencastle and Payne. Thank you so much.
Thank you, Natharis, Senora Romero, for having me today, and thank you for entitling us to be scientists, which I always am proud to be, a scientist of law, although dissecting of law is not as painful as dissecting a frog or a human being. But yeah, we can be painful as well when we go to court. Yes, regarding Greencastle, to break it down to scientific analysis, what Greencastle did really is that it put or addressed lawyers working with witnesses on the process of how their witnesses should present their witnesship. There are ethics that have been put in the guidance, and that's what we are looking at today. That has been a decision in court, and the decision in court can go as far as it might, that we are going to discuss today. How will it affect arbitration? Will it affect arbitration? There are lots of people who say, arbitration, it's up to the tribunal. To a certain limit, yes, it is to the arbitration tribunal, but courts will interfere should parties refer to the courts, and then it will become a court matter. So we have to keep this in the back of our minds, that courts are by facto are overlooking the procedures, and they could be referred to in one whimsical application to the tribunal to refer to courts. So it still is there. The shadow of the courts is still there. Now, what did Greencastle really do? The fact that Greencastle, what the judge literally said, that he blamed the lawyers for, I'm using Dr. Cartoni's expression, for not having the due diligence with the witness statement. They did not do their real efforts to verify how the statement was provided to court in a pre-trial. And again, I'm quoting your words, Dr. Cartoni, it's a pre-trial. So we have to be really, really analytical here. It's a pre-trial in a court and not an arbitration tribunal. And the judge, in his very critical manner, criticized and addressed the criticism to both parties. It is very important to understand. Both parties were blamed for how that statement arrived to the judge. Now, the most important outcome, really, of this decision is that the most contentious part of it is that the requirement to identify the documents that has been provided to the witness in order to get his witnessship. That's the part of the decision of that case that really affects. Provide the documents, we have a barrier wall here. If some of these documents are not really supposed to be openly provided, confidential documents, documents that contain certain secret formulas. The witness is a scientist working for the claimant, and he has an entitlement to the opinion regarding the documents, but the documents themselves could not be provided. Would that invalidate the witnessship? Would that actually annul the witnessship? To arbitrators, this matter of being brief, being to the point with the witnessship, it's not it's not strange to us as arbitrator lawyers or arbitration practitioners, because not all of the arbitration practitioners are lawyers. So this briefing and having a witnessship straight to the point, cutting down on the looping and bypassing, it's not strange to our practicing. So we do not find it strange. As a matter of fact, there has been calls for years requiring arbitration witnessship to be more concise, going back to the basics and getting it to be professionally looked at. Now, I have to point out something very important in the practice directions 57. This practice direction does not apply to the following procedures. This is rule number 113 and 139. It says proceedings relating to adjudication awards under section 9 of the TCC guide. So literally, the practice directions themselves related to one aspect of ADR, which is adjudication. It says those rules do not apply to adjudication awards. That's in 139 of the practice directions, PDs. So that is an indication that there is no immediate effect on ADR. However, what is the industry? As you said, Netherlands, in Singapore, they produce the introduction of the conference witnessing. But that's a completely, I'm borrowing your sentence here, Dr. Cartoni, it's a different aspect of questioning witnesses. However, that's the effect of Greencastle. You asked me about a specific question, and I'm just do not want to take the whole floor to myself, but I guess I can pass the baton back to you if you have any other query regarding what I said. And I hope I have answered your question as required.
Yeah, Antonio, microphone.
You're right. I was wondering, listening to you, Mohammed, Mr. Rafa, what sort of principles can we distill from the Greencastle versus Payne case applicable to arbitration procedures, specifically in international scope?
Those involved with the English seated arbitration, they will need to be aware of those changes. Because, as I said, eventually your award will be referred to court, because, as I always say, at the end of the award, you have at least one unsatisfied party, if not two. Mostly the losing party will always be the unsatisfied party. And then if you have awarded an award that is not matching the wishes of the winning party, then you will have two on your hand. So there is a possibility, there is a big possibility that one of those parties, and if they have lawyers, they will definitely seek an extra step, challenging your award. And eventually you will come in front of a court. Now, be aware that these procedures that you have went through, allowing certain witnessships, witness statements to go through, in spite of it might look against certain regulations, certain common law decisions, meaning precedents. That's when you really need to be careful as an arbitrator. We will come later in the discussion, I hope, to what should be looked at. But one of the things I want to explain very simply, that case is not against arbitration. As a matter of fact, there was a lot of frustration between arbitration practitioners, and it showed up in the very much in the Prague Rules, where it really it included significant changes regarding the standard approaches to witness evidence, how it should be dealt with. The ICC task force, I hope you all heard of it. They came up with lots of answers coming from lots of arbitrators, arbitration practitioners, who poured their hearts out specifically regarding how witness statements are prepared nowadays. And they called it over-lawyering. And I'm using here a judge's quotation, so I'm not accused of being anti-lawyer. It was literally in a case when his lordship mentioned that over-lawyering of witness statements, getting the witness to argue the case before even the case is argued by the parties. That's part of what arbitration practitioners were trying to get over it. I'll just name but 3 points here. Over-lawyering, a vehicle for submissions. Some lawyers use this, the witness statement as a vehicle for submissions before they submit it. Number 3, longer and longer witness statements that consume time, more and more expensive because the time gets longer, and the witness is fed what he should say. Very much outside the real nature of arbitration.
Okay. In your opinion, Mr. Rafa, do lawyers have a duty of care to the court arbitral tribunal, I mean, or to stay in it? In other words, do lawyers have a duty to be diligent?
Diligence towards whom? Diligence towards the tribunal, or diligent towards their client, or diligent in briefing the witness? Diligency is professionalism. So I guess your question is, are you asking me whether lawyers should be professionals or not? If we recall the same words of the judge in Greencastle, he literally said, "This is the worst witnessship I ever saw in my life, and it pours, it sweats with unprofessionalism." And it wasn't, by the way, this is a court judge, so he is entitled, I mean, his lordship was entitled to say it as much as he wants.
Yeah.
But his criticism was directed at both lawyers of both sides, because I read the witnesship. Honestly, I really read it. It's a summation. The witness was literally providing the summation that a lawyer would present in that case. So it is, this is a professional roundtable. So it was as I agree with the judge regarding what he addressed the lawyers with. And that's actually the most I could say in this professional roundtable.
Yeah, when you before mentioned something like practitioners in arbitration so talkative without a name. I mean, in terms of U.S. parliamentarism, doing acts of filibusterism is not welcome somehow. So then, and in reference to this case, judicial case in this case, the role of the players, I mean, specifically the lawyers in here, did they make a mistake? Did they make a wrong, misunderstood? Or it was an issue of tactics?
Can I pass the baton to my partner and friend, Dr. Cartoni, please? Because I know that he was discussing this matter very professionally and emotionally. So I will definitely give my comment on it. But do you mind, Nethers, if I actually ask Dr. Cartoni to answer?
Mr. Cartoni.
Mr. Cartoni.
Have an idea about this? What do you think about filibusterism in tribunals, in court? And in this case, it was real a mistake, or the opposite, it was a sort of tactical approach to the term?
First of all, thank you to the Iberian chapter for inviting me at this round table alongside my mentor, Dr. Raffa. It's a great honor for me. I'm not a scientist, I'm only a craftsman of law. But I try to answer your question. Filibustering is something that we as arbitrators should not allow, and something that we as lawyers should not indulge in. In this case, I think that it's quite difficult that it's a genuine mistake, because the mistake is too big. And the lawyers are part of a very renowned law firm, very renowned worldwide. So, this firm does not, he's so good as he has renowned for, or this was a guerrilla tactic. And for me, the latter is more probable. But anyway, I would come back on the previous question about the duty of care. I think that we lawyers have a duty of care to the court, because we as a solicitor are officers of the court, even though barristers are not. And also lawyers in India are officers of the court. This is stated by statutes. But anyway, even in Italy, we have an ethical duty not to mislead the judge. So we should exercise our best care and diligence in drafting our written pleas, but also written witness statement in the countries where this is the form of giving evidence. This is my view.
I mean, Mr. Cartoni, Greencastle and Payne is an English court decision about a civil proceeding, but we are, why should we discuss it here in an international environment? Can you illustrate the audience concerning why we mix.
From my point of view, Greencastle and Payne and practice direction 57 are not directly applicable to arbitration, but I want to stress the word directly. We have to look at the principles that they are behind Greencastle and Payne, and such principles could be applied to the international arbitration worldwide, not the black letter law of practice direction 57 that shall apply only to civil proceedings before an English court. But Greencastle versus Payne, in my view, is important because the judge allow the party, the claimant in this case, to redraft its witness statement. And this is the principles, a right, a possible hypothetical right of the parties to cure its own defective evidence or written defense. And this could eventually be applied to every arbitration. And I would like to know on this point the opinion of Dr. Raffa.
Right. The opinion of Dr. Okay. Let me suggest to you this. Thomas Kelly has written us a question regarding precisely the different roles of witness and expert. And said the following as a question. The role of the expert witness was laid down in the Iberian refer, where the expert's duty is to the tribunal and not the instructing party of the lawyer. So is there any sort of clear difference between the role of witnesses in general in front of the experts in their statements, in their instructions to the tribunal? So then a different, two kind of loyalties, the witness with the lawyers and the experts with the tribunal, or it's the same, or both with the same loyalty, or in fact, we can share one from another?
Is that for you, Bernardo, or for?
Yes. Okay. I think that we should distinguish the expert appointed by whom. It is true if we are talking about the tribunal appointed expert or the court appointed expert, that he has his own duty of loyalty to the court. Mm-hmm. But in many cases, we have party appointed expert.
All right.
And they are, and in many jurisdictions, a party appointed expert is a witness, is a mere witness. There is no difference. Anyway, in arbitration, we distinguish, but also in civil proceedings, we distinguish about lay witness, the witness about facts, and expert witness. They are witness of opinions, but they are, from a legal point of view, they are the same beast.
Right.
Can I just add to Bernardo's, emphasizing Bernardo's point? When you mentioned loyalty in legal principles, loyalty should be one and the same, which is the justice outcome of that dispute. Whether you are an expert witness or a witness belonging to a party, the loyalty itself in legal terms, and if found in law, in court, if found that the witness has manipulated the truth, he will be punished or she will be punished. So in real terms, legally, loyalty should always be to the tribunal or to the court for the sake of arriving to a justified resolution. So the word loyalty itself, I'm sorry, I always, because I pay attention to words when I'm sitting as an arbitrator, so words are vital here. And when you use the word loyalty, then to witness, as Bernardo said, exactly, witness are the same witness, whether experts or brought in by a certain party, they are the same face for the same beast.
Mm-hmm. Thank you, Bernardo and Mohammed Nazaret.
I
have
would,
something to say.
yeah, I would like remark, Bernardo, concerning if we can think about the localization theory regarding Greencastle and Payne, if we think in international arbitration, what do you concern about it? I know maybe it's not, maybe it's not widely accepted, but in your opinion?
Thank you for the question, Nazareth. This is a really stimulating topic. Greencastle versus Payne can be more easily applied to international arbitration if we are following the so-called delocalization theory that try to cut off any links between the arbitration and the law of the seat.
Mm-hmm.
And this is a principle stated in some cases like UCOS versus and Rosneft or Cromalloy and Egypt. But it's, as you mentioned before, it's not a wide recognized principle. And we are a lot of other cases that stated that no, the law of the seat is deeply rooted in arbitration and cannot cut off. And I refer, for instance, to Bank Mellat and Eliniki Techniki.
Mm-hmm. Well, let me take the second part of the conversation. Bernardo, please, will you give us a short introduction about CIArb Singapore Guidelines for witness conferences in international arbitration?
Yes, I can add only a few words at the very clear and precise introduction that Nazareth Romero did at the beginning of this webinar. The aim of the Singapore rules are, and I quote, to assist the tribunals, parties, and experts to achieve an effective and efficient witness conference and to minimize the risk of the process going awry. The new feature of this guideline is the conferencing. So not the witness examined one by one, as usual, with the usual structure, examination in chief, sometimes replaced by the witness's statement in right, cross-examination, redirected examination, but to put witnesses and moreover expert witness together in order to speed the proceedings, to confront the different opinion of experts or the different views of facts of the lay witnesses, and to help the arbitral tribunal to reach the best outcome possible, the more just and equitable outcome possible. And one very significant feature of these guidelines is who led the conference. And it's up to the parties and the arbitral tribunal decide if this conference is led by counsel, as a usual international arbitration, especially in Anglo-Saxon world, or led by the arbitral tribunal, that is a more inquisitorial approach, but also this conference can be led by the expert or the witnesses themselves. And this is really a novelty. Anyway, an in-depth analysis of those guidelines, it's too far for the time that we have, and could be a subject of another roundtable. But I think that these are the main points, the main interesting points of the Singapore guidelines on witness conference.
And in the topic we concern is a question both of you. How can Greencastle and Payne interfere with CIArb Singapore guidelines? What do you think both of you?
After you, Bernardo.
After you.
The impact on international arbitration. Witness statements in commercial litigation was mostly counselor-led, and now, in view of the PD 57, it should be witness-led. However, the interface between arbitration and litigation in London, it is mostly will come clearer when there are applications to the courts. Now, how do we think it will go ahead? One of the famous arbitration institutions, London Maritime Arbitration, they already moved and adopted similar approaches to the PD 57. In their Schedule 4, Paragraph 2, in the 2021 terms, it was applicable to arbitrations commenced after 1st of May 2021. They literally applied the PD 57. In the ICC rules, they provide, in ICC rules in 2021, provided the tribunal with the power to limit the length and scope of written evidence in the expedited procedures. In the London Court of International Arbitration 2020, they provided the tribunal with powers to decide the manner, form, and limit of such statements, which means that the tribunal is entitled to limit, criticize, direct how the witness shouldn't be. The IBA Rules on the taking of evidence in International Arbitration 2020, Article 4.5b, it is unchanged from the 2010 articles. It states that a witness statement shall contain a full and detailed description of the facts, the source of the witness's information, and those facts sufficient to serve as the witness's evidence in their statement. So if we see that the practice of arbitration has already been within what the PD 57A is recommending, and I just here refer to Article 2.2 of the PD 57, it says, trial witness statements are important in informing the parties and the court of the evidence a party intends to rely on at trial. Their use promotes the overriding objective by helping the court to deal with cases justly, efficiently, and at proportionate cost. Exactly what Dr. Cartoni said from his reading on the Singapore conferencing. It's incredible. I see that PD 57 will have a big and I think a positive impact on the approach and contents of witness evidence in English seated arbitration. The LMAA, which is the Maritime Arbitration, is an indication of that. It still remains to be seen whether others will follow swiftly or they will take their time to do it, because the practice is there without being written directly as a PD 57 direction. On the other hand, provisions like 57A It will take time, as usual with arbitration institutions. We always take our time to amend. We will not be in a hurry to do it. We will look at the markets, and institutions would eventually consider similar provisions. How soon? I haven't got my crystal ball, but I believe that this is coming. The result would be that neither, because of the consenting nature of arbitration, the parties can be agreeing on that on your interim meetings. I can be, as a tribunal, set the ground rules for how we go ahead, including rules such as the PD 57A. These can be provided for, agreed upon consensually by the parties, and it will literally disallow any disadvantages to any of the parties when they present their witnessship. So it's a matter of practice rather than writing for the time being, but I believe that's the way ahead.
Bernardo, have you
No,
a position on this?
the question was if Greencastle versus Payne interfere with the Singapore guidelines. In my view, few, because Greencastle versus Payne is dealing with written evidence, while Singapore guidelines are on oral evidence. But we can find a point of contact, and we can find such point of contact in the specific direction number 3, and I quote, "Each witness shall confirm that the written evidence submitted by them is their own and shall identify any correction that they wish to make." And if we deem the arbitral tribunal vested with the power, with the inherent power to cure the defective evidence as stated in Greencastle and Payne, this is the point of contact, and at such stage, the arbitral tribunal can underline to the witness whether or not his own statement is defective and give him or her the opportunity to amend it.
All right.
In my opinion, this is the only contact point.
So
Thomas Kelly is asking a question and saying that in relation to the experts in the English courts, a biased witness can be prosecuted.
all right. Are you going to answer this?
And she says, Dr. Muhammad Rafa addressed the duty of the witness, both expert and fact are to justice, irrespective of whom they represent. Regarding a biased witness and whether they can be prosecuted in criminal courts or not, it is not really clear cut there, Kelly. There is a biased witness will not be incarcerated, and sometimes the other party will not even bother to sue a biased witness, because if I bring the witness, most of the times they are biased anyway. And it also is very difficult to clear cut the biasness, whether I'm saying the truth in a biased way or am I biased in a truthful way. So you're talking to lawyers, and we will make sure definitely that your case against the witness will be very difficult. So we do not rely on that. We rely on the principles of the fact that a witness should say the truth. When we talk about a witness lying to court, that's a different story. Held in contempt of court, that's a different story if you lie to court. And of course, yes, they can face incarceration, etc., etc. But in arbitration, that's, I wish.
If I may add a few words, the problem is that false evidence and forged evidence are criminal offenses. And this is a fact. But biased evidence is not a matter of criminal offense. It's a matter of reliability of the witness. I think that almost every witness is somehow biased because of his own culture, experience, belief. I think that the really genuine, unbiased witness is something that does not exist. So this is on the ground of reliability and weight of evidence. Only false statement, false evidence, forged evidence are criminal offenses.
Well, let me continue with a question to Mohammed Rafa. You have mentioned before to twice rules from the maritime applicable to maritime arbitration issues. So then, don't know how, but makes to my mind the position. Again, we are talking about the Greencastle versus Payne sentence. What about the sort of rules as the IBA or the so-called Prague Rules as soft rules? What kind of impact could the sentence of Greencastle versus Payne can have on them? Are they? Is this expecting to suffer a kind of rethinking about the extension, the applicancies of these soft rules? Are they going to be changed in some way?
Yeah, I'm glad you mentioned the Inquisitorial because I really wanted to bring this point in. According to, I will recall the requirements here. The witness statement must verify this, his witnessship by a statement of truth. And the most important thing, this is rule 4.1 of the PDA, and it says that he has to verify it by a statement of truth and sign it himself, or the witnesses sign it themselves. I'm using the word themselves because it is said like this even in a later requirement. However, point 4.3 of the PD says a trial witness statement must be endorsed with a certificate of compliance in the following form, signed by the relevant legal representative, by the lawyer. So it has to be endorsed by the lawyer. However, if we look at the Hague Rules on business and human rights arbitration articles, unless otherwise directed by the arbitration tribunal, statements by witness, including expert witness, must be presented in writing and signed by them. We go to the Inquisitorial Rules, Article 27.2 of the Inquisitorial Rules. Witnesses, including expert witnesses who are presented by the parties, unless otherwise directed by the arbitration tribunal, statements by witnesses, including expert witnesses, may be presented in writing and signed by them. None of the Inquisitorial Rules, which is, well, it is supposed to be reflected in many real laws and rules, none of them mentioned signed by the legal representative. What happened in Greencastle is the lawyers were reprimanded for the fact that they endorsed the bad witnessship. That's the key that we have to really focus on. Greencastle, the blame was addressed to the lawyers because they had to add that endorsement. And the judge, well, reprimanded the lawyers for not, well, really hinting, did you really read that statement? If you would have read it as professionals, you wouldn't have allowed it to stand in front of me, more or less, in very simple words. So that's the big difference between arbitration and litigation. Now, the fact that witnesses will be presenting and signing it without the lawyer having the responsibility for it, then the option is for the tribunal. Remember the comments of the judge in Greencastle, what he said: this matter should not be left for the real trial to come and then be sorted out. Thank God for the pre-trial. So he referred to the pre-trial role. We have something similar, but sometimes in arbitration, you get the witness statement way in the middle of the hearings. So there is no pre-trial in arbitration. There is there is the interim meeting, but that's not a pre-trial. What you are faced here is, yes, as a tribunal, how will you deal with a witness statement that comes in that form? And there are no lawyers. There is no necessity to have lawyers sitting in front of you. Parties could be representing themselves. There could be engineers sitting in front of you.
Perfectly.
Yeah.
So there is no factor of lawyers that you can actually blame. Thank God. So,
Thank God.
so the fact is,
Yeah,
you
yes,
as a
yes.
tribunal have the
I know,
role.
I know. What a nightmare. What a nightmare.
So that's my point.
Right. Bernardo.
And
Oh, Nazareth. No, sorry.
no, I mean IBA rules or Prague rules concerning Greencastle. You mentioned the Haga rules from business human rights arbitration. Which one, Bernardo?
In my opinion, Greencastle and Payne can be more adapted, more fit with the inquisitorial role set out in the Prague Rules.
Why do you mean inquisitorial, Bernardo?
Because Prague Rules are, as everyone knows, are a set of rules drafted in Central Europe, mainly by civil lawyers, as a form of reaction to the IBA rules that they deemed too prone on the adversarial system, too similar to the Anglo-Saxon way of taking evidence. And this is, they are called inquisitorial. By the way, in their own name are inquisitorial rules on taking evidence. So it's not my word.
No, okay, it's for the audience that explain much better. Thank you.
While Article 4.6 IBA rules, I mean IBA rules on taking evidence 2010 version, allows modification and or integration to witness written statement only in very specific cases. So this is something that collides with the Greencastle Payne decision.
Yep.
And also Article 2.1 of the IBA rules state that parties, the arbitral tribunal, must consult the parties in every matter regarding evidence and agree. So modification to how taking evidence can be made only by agreement of all parties. And if my other party has a defective evidence, I will not ever give my consent. So it's that practical point of view is inapplicable, Greencastle and Payne, on the IBA rules. But anyway, we can think of that Greencastle and Payne can be a court decision. IBA rules are soft rules, and which is the importance and the weight on a court decision against soft law, soft rules. But it's also true that if IBA rules are incorporated in the arbitration agreement, they become will of the parties. And as everyone knows, will of the parties is the cornerstone of the arbitration. And in such a case, surely will prevail on Greencastle and Payne.
Mhm.
And in your opinion, Rafa, Mr. Rafa?
I agree with Bernardo, because Article 32.2 of the Inquisitorial rules allows the following tools to be at the disposal of the arbitral tribunal, and it is at the discretion of the arbitration tribunal to direct the order of proof, bifurcate proceedings completely, exclude cumulative or irrelevant testimony or other evidence. It set limits to the written statements presented to it. It's at the disposal of the arbitration tribunal to dispose, take into account, exercise its authority over witness statements at whatever stage it is presented to the tribunal. And as Bernardo exactly said, in exercising its discretion, the tribunal should be guided by relevant best practices. You mentioned the word international, in other words. So the best practices of the seat or where the arbitration is taking place, the taking of evidence in international dispute resolutions, including mostly those relating to the most referred to the IBA, regarding rules on taking of evidence in international arbitration, as Dr. Cartoni rightfully said. So we will find at the end of the day, and you asked us the billion-dollar question is, what do we think?
Yeah, no, I was thinking about it. Yeah.
Yeah, and to tell you the truth, it will boil down to the practice of the tribunal and how the practitioners will apply it. As Bernardo mentioned 2 seconds ago, it's a soft law. Take it or leave it. I will not be sued or challenged on me choosing a soft law or not choosing it. But I will be challenged on my practice, my procedural practice, and that has to be word by word to the procedural law or regulations that I'm following. That's what we should be careful. As long as the rule is soft, it is not procedural, it is diligence, using the word Bernardo.
Well, let me see. About not being soft rules, not as soft as it should be. And regarding an expression you use, disposal tribunal, arbitration tribunal, about the means. So then, I want to be very practical and focus on the time. Article 32 of CIArb Rules. Bernardo, give me your opinion. The sentence we are talking about, Greencastle versus Payne, is current with Article 32 of Prague Rules, and the CIArb Rules, the CIArb Rules of Business and Human Rights Arbitration. What do you think?
Yes.
Would you like to read the article? Or you have...
Yes, I think that is coherent, and to demonstrate this, I would like to read the article to the attendees. And Article 32.2 says, and I quote, "The arbitral tribunal may organize the taking of evidence in the manner that it deems appropriate to enable each party to effectively present its case, taking into account relevant best practices in the taking of evidence in international disputes resolution and the circumstances of the case, including consideration of fairness, efficiency, cultural appropriateness, and rights compatibility." But it's also Article 32.4 that it says, at any time during the arbitral proceedings, the arbitral tribunal may, on its own motion or at the request of the party, require any party to produce documents, exhibits, witness statement, or other evidence within such a period of time as the arbitral tribunal shall determine. So I think that even in the other principle, we have an inherent power vested in the arbitral tribunal to cure defective evidence, as we shown Mr. Justice Fancourt did in Greencastle and Payne.
Would you apply, if you were sitting as arbitrator, would you apply Greencastle and Payne decision?
$1 million question.
$2 million question.
2 million. The bet is up.
I don't get out of bed for less than 100. So.
Well, okay. Hypothetical.
I would like to have a witness statement as recommended by the judge, and I would like parties to pay attention to the witness statements they present to the tribunal to be within professional and justifiable statement, indications logically, so that it helps the case rather than submit the case. I would like to have it that way. Will I have it that way? My guidance, my speaking to the parties beforehand and putting the rules of how this tribunal will go ahead is vital for how the tribunal will progress later on. I assure you, my preliminary meeting with the parties is the key issue on how each party will be looking at the tribunal, respecting the tribunal requests, and going ahead with it. So I would love to have this, and as I mentioned before, the industry is very much welcoming that decision, very much because we were looking forward to it. We are suffering from bad witness statements. We would like it to affect it, but does it have the power to change it or not? I don't think yet, unless it is, as I mentioned before, English seated. Then the tribunal and the lawyers will be worried from going ahead and standing in front of a local court to look at a certain point of the procedure of the arbitration.
You have just remarked one important thing that previously Mr. Amusategui and myself was talking about: preliminary meeting with the parties. Preliminary meeting with the parties. Or later on, first procedural order. Relation with the proof, witness conference. What do you think is important in this procedural, of course, in the preliminary meeting and in the first procedural order? In the point of arbitrator, I mean.
Can I leave the answer to my preferred partner in the world?
Of course, but later on you answer too.
I didn't name, so he knows himself. Allora.
You leave to me the hot potato.
The hot tubbing conference.
Here
okay. Okay. Really a good and a hard question to answer.
I love you.
And also we don't have
I think that in the case management conference and in procedural order number 1, the hypothetical arbitrator, or the arbitral tribunal, should explain the parties what we expect from them in terms of evidence, and in terms of how to give us evidence? And furthermore, what can be the potential consequences of non-compliance with our direction? This is my view.
Total agree. Total
By the way,
agree.
consequences here is
Yeah.
really important, because Bernardo, in your notes, you mentioned that something very important out of this Greencastle case is the judge did not order the dismissal of or annulment of the witness statement.
Yes.
The judge ordered the correction, take it and bring
Yeah.
it back in a better form.
Yes.
So the consequences in arbitration, actually, the only thing I could do is penalties. I can only just impose penalties or extra costs. So
Yeah.
I cannot even order them to take this witness statement and bring it back to me. I don't have that authority. I can
Yes.
amend it, I can ask it, but if he presented the same thing to me, the only thing is I can burden him with extra costs. So as I said, if I want to be obeyed, I have to know my authority. And my authority is the only thing I have is to order costs. And I can refer to the court. I can refer to the court to order them to do something. But the question is back to you now. Would you go actually to court and ask the court to order the witness to change the wording of the statementship? I don't think the judge will appreciate wasting his time for that.
Yes, you can do an adverse cost order or some other penalties.
Yes.
And as you told me some years ago, when I'm signing my order on my word, my pen is the most powerful tool in the world.
Exactly. It is. It is. And by the way, when you sign that order, the most important thing, if you know the power of your pen, you must understand that you cannot sign an order unless you know it will be obeyed and fulfilled. You cannot sign an order that you know or have a doubt they will not be able to fulfill it. You can't. Then you are literally throwing your authority out of the window.
I agree.
So then, as it is said, know the gun's kill, the man who takes the gun's kill. So is the soul of the man who takes the pen who can fail with the justice. So let me ask you, well, we have 10 minutes close to the end. Let me give you a last question. I mean, perspective, despite what audiences could say. I have this. Think about the future. Let's do some forecasting. What main challenges about witness evidences would be in the future? Have any suggestion on how to face the future, to face the evolution of the arbitral procedure, practices, better actions suitable for that?
Well, if you're thinking about my future, I have my future in the background. That's my sailing boat in the back. So that's my future. So that's what I'm thinking about after I finish with this meeting. Regarding what will happen is that arbitration, I was talking to two of my other partners yesterday from Saudi Arabia. And Saudi Arabia has recently legislated their Arbitration Act, which is 98% matching to the UNCITRAL law. 98% in Saudi Arabia. Of course, it's a very clever move because they want to encourage trade, and they want to encourage trust and confidence in trading with them. So if you are talking about the future, it's a matter of practice. It's 100% practice. Arbitration for hundreds of years has been practiced, and it will remain for the next 1,000 years practice, governed by formality. I was having that sentence with Bernardo, and he said, yes, arbitration is informal. Yes, it is an informal process, producing a formal decision. And that's what arbitration is all about. Formality which will produce a very effective and enforceable formal decision. And that's what arbitration is all about. You will see many cases like Greencastle. You will see many situations where the court decisions might affect how lawyers will act in front of you. But remember, it's an informal producing a formal. That's it.
Informal or flexibility? Because I don't like, excuse me, Mr. Rafa, I don't see informal. I say to my students, flexibility.
I agree with you, Nathras, but what I meant by the word informal, I know because my wife is German and she usually translates the word straight on. So
Excuse me.
what I meant by informal, please do not take it the offensive way it is meant in Spain or in Germany. What I mean by informal, it means if I choose, or the parties and I choose to go ex equo e bono.
Okay, eta equo e bono. Okay, agree.
So I'm saying it's informal within what the law allows it to be, but it's still informal.
I'm agree with you because you explain what you mean
By the word informal, yes, yeah.
Sometimes it's very important. Thank you. Thank you so much.
But the flexibility, as I agree with you, is flexible because of its informality. But remember, once you produce the award, there is no informality, no flexibility. It's there.
No. Okay. Antonio Amusategui, the floor is yours.
I was going to ask Bernardo Cartoni for his foreseen in the future of arbitration. Has said not very much. Again, a hot potato for you.
I have forgotten my crystal ball at home, so it's difficult to me to answer. But anyway, I think that one of the main challenge in the future, but also in the present, is the use of technology.
Right.
Use of technology in arbitration can be really useful in terms of cost savings, efficiency, time savings, but there are new problems. So the digital divide between one party and another, that is can be in international arbitration between parties located in very different parties, and also the issue of time zone. If we have an arbitration between a Californian company and a Hong Kong seated company, while the arbitral tribunal is sitting in Central Europe, it's difficult to agree on a scheduled time.
Different cultures.
Or maybe it's stimulating because we need negotiate.
And also regarding witness examination, we can do the witness examination even remotely, but when is the witness? It's all alone, maybe okay, or there is something watching him, and moreover, is sitting alongside the party that is calling him to hear evidence. It can be a problem because there is an imbalance between the one party that is in front of the witness, it can see in his eyes directly, and the other party that is located 10,000 kilometers away. This can deemed as a breach of the due process of law, of the fair and equitable process in arbitration, and it can lead to annulment or non enforcement of the final award. I think that scholars and practitioners can help us in the future to solve all these issues.
Mhm. Well, thank you, Bernardo, and thank you, Mohamed Rafa. Well, I think it is time to end, so I have to congratulate our presence here, Mr. Mohamed Rafa and Mr. Bertano Cartoni, talking to us very interesting topics and criteria about witness conferences and expert conferences. I have to appreciate Nazareth Romeo being here. And as last, for my part, just to remind the attendees that updated information for future CIArb webinars organized by the Iberian chapter will be ready to be announced in the CIArb webpage. And in this, about the case of this event, you would like to view the recording that will be available on YouTube, CIArb YouTube account in next few weeks. And the last for me, thank you all you for joining, attendees. Thank you, Mohamed. Thank you, Bernardo, for your words. Thank you, Nazareth, for your help. The best of you all.
Adios.
Thank you, you too.
Thank
Bye-bye.
you. Thank you very much. Bye-bye.
Bye.